Hi, this is Whitney, and I wanted to do a short video on guardianship and conservatorship in Virginia. I get asked a lot, what happens if mom, dad, siblings, or whoever doesn't have capacity, either because of a car wreck, or maybe it's a traumatic brain injury, maybe it's dementia, Alzheimer's, mental health issues, but for some reason this person cannot execute a power of attorney over their finances and over their medical decisions. And so family members are left with, well, who can make these decisions? Who has that power? Nursing homes, banks, lending institutions, people who they owe money to, need someone who can step into that role and pay these bills and make sure they get the care they need. So what happens if you don't have the right sort of estate planning or powers of attorney in place? Well, Virginia has what's called a guardianship and conservatorship proceeding. That is a big fancy way of saying the guardian has control over a person, their location, the care they get, medical, mental, where they live, nursing home, rehab, hospice, that type of thing. And then you've got the conservator who is over that person's finances. And so what happens is if we don't have the powers of attorney, we have to file a petition in the circuit court where the person lives. And you have to give notice to all the relatives, siblings, children, parents. Everyone has a right to hear what's going on, and notice has to be given. A guardian ad litem is appointed for the adult who you are trying to seek guardianship and conservatorship over. That guardian will meet with you. That guardian has to meet with the incapacitated individual and will determine if they actually need this care and this order in order for them to make decisions and someone to be in charge. So that's kind of the guardian's role. After all that's completed, we have a hearing whereby everybody has notice. Again, parents, siblings, children, they all legally are entitled to notice of the hearing date, as well as the incapacitated person is also supposed to have notice and is required to have notice. We have the hearing date, evidence is taken, why you want the conservatorship, why the guardianship is needed. You will have to have a letter or records from a medical doctor or perhaps a mental health professional licensed that can make the determination that this person does not have capacity to make the decisions for themselves. This hearing is not taken lightly. It strips everyone of any right they may have, the right to vote, the right to make any decision with regards to their well-being, and it is taken quite seriously. This is usually something that families have to face when proper planning is not done. I know a lot of people don't think that they need a power of attorney, or they think that that doesn't apply to me, maybe because you're married. I will say a lot of times people find out that they need one when they least expect it. And usually it's too late. It's usually the children or perhaps a spouse that has to go through this because it wasn't deemed important enough to do the powers of attorney. So in short, the answer is please do your power of attorney. Come see me. I'm happy to walk you through. It's not some big scary thing. We can certainly tailor it to your needs and your wants and your wishes, but just please get it done. It really saves your family, your family, the heartache of having to go through court proceedings to be able to make sure you're taken care of. And so I just strongly encourage you, think about it. If you don't have one in place, or if it's super old, I would also encourage updating it, just because laws change, certain powers change, and what you can and can't do. So come see us, come see me. Happy to help you as always. And the number is 276-477-1422. And as I always say, we look forward to seeing you soon.